Hey, everybody. Welcome back to the weekly immigration news recap, where we break down what changed in U.S. immigration this week and what signals came from the Trump administration that could impact your immigration situation if you're a foreign national, or your client strategy if you're an immigration practitioner. Today is Thursday, August 21st, at around 1 p.m. Eastern Standard Time. And this episode will be released tomorrow on Friday, August 22nd. To cover all the immigration news that happened this week with me, I'm really lucky to have Shobhana Kasturi, owner and immigration attorney at Kasturi Law. Shobhana, thanks so much for making the time to recap the news with me this week. And we'll get into your background and your practice in just a minute. But first, tell everyone where you're joining us from and how your summer's going so far.
Sure. So first, let me thank you, Finn, for having me. I think it's a great opportunity, and I do justice to the call today. I am based out of Naperville, Illinois. I like to say Chicago because it's only like 30 minutes from Chicago, and I'm a true and true Chicagoan. My summer has been extremely busy and uh, travel based, but I'm enjoying it. Those of us who live in the Chicagoland area, we value every single day of summer. So I'm hoping that summer lasts till December.
I do a lot. I used to do when I lived in the States a lot of road trips across the country, and Naperville was always my go-to as a stopping point to stay at because you want to avoid the Chicago traffic as much as possible. And I have a dog. Naperville
Oh,
just has like a lot of beautiful parks, and so I'd always
yeah.
book a hotel right next to a park in Naperville, and it was always such like a nice sort of real American community. It felt like.
Yeah, it's one of the best towns to live in. I mean, I could go on and on, so don't want me to, but I've lived here since 1998, so I love it. But I love the city too, so it's like the best of both worlds.
Yeah, yeah. I mean, having Chicago that close
Yeah.
is quite the advantage. Okay, well, before we dive into the news, can you tell folks listening a little bit more about your professional background and your current practice and the types of clients that you support?
Sure. Thank you. So I'm an immigration attorney. I started Kasturi Law about 10 years ago, immigration based. I've been practicing law for over 27 years. Um, you know, I love the law. And before starting immigration, used to do a lot of transactional bankruptcy work, but I'm myself a first gen immigrant. So starting my own practice in immigration was the right thing for me. I'm self taught, but I love it. And in terms of the practice itself, there's heavy concentration in family based cases, but I do some employment based cases. I do a lot of consular processing. I do a lot of interviews, adjustment and naturalization interviews. So it's a gambit of things. And most importantly, I just love what I do. So hopefully that shows for my clients and in the results.
Well, we booked this episode weeks in advance, and we even had to reschedule. But it always seems to work out that I have the perfect guest with the perfect background for the types of news stories that occur in the week, and that's certainly true with you today with some of the stuff that we'll be covering. Shubham and I will spend the next 30 minutes or so breaking down all the important developments that happened in the immigration news this week. We're going to focus primarily on what's happened inside the Trump administration, but also a couple of litigation updates from the courts. There's nothing new from Congress this week since the House and the Senate both remain in recess and will be until September 5th. So we'll skip over that. As always, in some cases, we may just recap the headline, but in others, we'll go a bit deeper and try to provide a bit more context around why that news story could be a signal or a real factor that will impact your work if you're an immigration practitioner in the coming weeks or months. And then at the end, we love to save a little time for our guests to talk about a trend or a story that they're seeing and keeping a close eye on, but maybe hasn't been getting a lot of coverage or attention. So it's an under the radar story. So, Shabna, are you ready to jump in?
I'm ready. Let's go.
Awesome. So I'll go ahead and share my screen and we'll talk about our first story, which is sourced straight out of USCIS. So this happened on August 15th, so at the very end of last week, but it was quickly sort of became the talk of immigration attorney LinkedIn over the weekend and in the early part of the week, which are the changes that were made to the good moral character evaluation for naturalization applications. So this policy memo, I actually found out yesterday that it was accidentally leaked from Doug Rand, who is the former senior advisor to the USCIS director. I thought that it was just released, but he was saying he thinks that USCIS typically when these policy memos come out, they try to coordinate it
Mhm.
with the policy manual actually being updated as well and that being released. This one sort of just slipped out last Friday, but Anyways, it is some changes that were made to the good moral character evaluation standard for naturalization applications. There's a lot in here, but Shubna,
Mhm.
I want to take it to you and just maybe you can flag some of the big changes that when you reviewed this document were you stuck out to you.
Sure. So I do a lot of naturalization cases, so this is definitely up my alley. Uh, Naturalization is the final fruition of the immigrant journey for many people. So this memo is a seismic change. Initially, when I found out about it, I was like, all right, it doesn't seem that bad. But then I started reading the memo. It's seismic. And let me explain what that means, right? So traditionally, or prior to this holistic memo, good moral character was reviewed over the statutory period, whether it was 3 years or 5 years, right? Um, so let's say you had two DUIs, or let's say you didn't pay your taxes and weren't in a payment plan during the statutory period. Those negatives, if you will, would be reviewed or looked at to see if you're eligible. Of course, when looking at good moral character, they look at conditional bars, permanent bars, um, mm, and so that's another factor. But let's say if an applicant, let's say they did owe taxes, but got into a payment during the statutory period, they were still eligible to show good moral character. So the burden has shifted significantly on the applicant. The burden's always been on the applicant, but what the new burden, as I see it, is you have to affirmatively show that, look, you're a person of good character. What does that mean? That means that you have to show you are employed, maybe you contribute to the society, you pay all your taxes, maybe you do volunteer work. So this is an affirmative step. Traditionally, case law has said that, look, you have to show that your good moral character is the same as the average person in your community. So I see this as a big shift because this is a affirmative, showing of your good moral character. And it'll be interesting to see because there are a lot of people naturalizing who may not be able, who are retired, who are not gainfully employed, or whatever the case is. So, how will it affect those applicants who don't have those, attributes or can't show it because of age or because of circumstance? And we'll have to see the trends on how those bear out. So that's just one aspect of this memo. The second aspect is that they're going to have increased scrutiny on the negatives. So let's say in the statutory period, you have a clean record, right? No tickets, no nothing, everything's good. But 10 years ago, you had a DUI or you had two DUIs or whatever the circumstances was, there's going to be more scrutiny on that. Like, okay, do you still deserve to have the opportunity? Are you able to show that you have rehabilitated yourself? And they're going to look to community voices, other evidence to show if the rehabilitation has occurred. And of course, when, there are criminal matters or other issues, there's always more scrutiny. That's just normal. But I feel like this has become a two-step approach, especially for someone who may have a more checkered background. And I think it imposes more of a standard than the average person in the community, right? Again, we'll have to see how it applies to applicants. Based on their backgrounds, based on their lifestyle, but everyone's not going to be able to, I think, affirmatively show some of the so-called positive attributes that may be required. Um, Another thing I think to watch is like the way this memo is framed is about totality of evidence. And totality of evidence is a standard that looks at the total picture, and I think that's fine. But because of what I perceive this as a two-step test, I'm curious to see how that totality of evidence standard is going to be applied. Now, the one thing that hasn't changed and always has been consistent, and something that I think is important, is the standard by which the benefit has to be met, if you will. It's the preponderance of evidence. Okay, so preponderance of evidence is 50% or more, right? So if the scale is 50% or more in your favor for the immigration benefit you're seeking, then you should be able, you should qualify for the benefit. That's something that's often not focused on, but I think practitioners should really focus on is preponderance of evidence, right? Looking at the totality and then the standard being preponderance of evidence. And that's what my approach is going to be as I navigate through some of these cases. Um, I want to leave this memo or talk about this memo, leave something positive about it. And that is, you know, the standard has been laid out, but we don't know exactly how it's going to be approached. We have to watch for the trends. And I don't think it's all doom and gloom, but it's certainly something we need to kind of watch for.
That was really thorough overview of sort of what the implications of this changes are, and what what you ended on there I think is a perfect segue. And I want to stay on this topic for just a second, actually.
Sure.
Yesterday we did our biweekly immigration insiders meeting with about 50 immigration attorneys, and then Doug Rand, who's the former senior advisor
Mm,
to the USCIS director. We also had Michael Valverde there, who used
mm,
to lead all 89 field offices at USCIS until
wow.
very recently.
Hmm.
And we pulled up the USCIS N400 processing data
Hmm.
from the
Hmm.
last 12 months.
Hmm.
And it's one of the most consistent, charts you could look at of USCIS processing for all of the different case types.
Hmm.
Very, very, very steady over the last 12 months and well before this, where, typically you're getting about the same number of completions each month. You have an approval rate usually around 91,
Hmm.
92%. It doesn't fluctuate much. And the processing times, sit around 6 months. It
Hmm.
doesn't really fluctuate much differently from that. What I want to ask you, as somebody who has done these applications for, many years now, and I think this would be useful for practitioners who are, trying to figure out, you know, if they need to change their approach to preparing these applications, and for applicants, right, who
Hmm.
maybe aren't yet at that naturalization stage in their immigration journey, but will be
Hmm.
soon, and this could be a concerning update to them.
Hmm.
First, maybe could you explain like what the average current preparation process of a naturalization application looks like with your clients? And then, yeah, I'll start there.
Sure. So, I mean, I have always approached naturalization cases a little bit differently, maybe than most practitioners. I'm all kitchen sink approach, right? I want to give the adjudicator the ability to approve it. So, while in most cases a good moral character, meaning the old standard, may not have been in place, I always am able and ready to provide evidence of taxes being paid, other attributes. I may not affirmatively provide the evidence, but we're ready to take it to the interview. In terms of like processing times, like, from the time that I get engaged to the time of filing, of course, it depends on how quickly I get the documentation. Um, it can be a turnaround of anywhere from 2 weeks to 2 months. Again, very dependent on the client. And of course, and this is like a basic case. If it's a more complex case, it can sometimes take 90 days. And something that I want people who are applying for benefits to understand is immigration is a marathon, right? So it's not always about how fast you file, but how well you file. So I always tell people before they hire me, like, do you want an attorney who is going to look at everything to help you get to the finish line, or do you want someone who's going to just file it tomorrow? Because if you want the latter, I'm not that person. Um, Not only because I care about what I'm doing, but you're spending money, you're paying me, so I want to do a good job. So I think from processing perspective, I don't necessarily see a slowdown within my office, but I do think I'm going to look at things even more than I normally do. I probably do that anyways, but I just think now with these shifts, that's just something practitioners have to be keen on. And immigrants wanting these benefits have to be sometimes more patient because again, it's a marathon.
Yeah, and this is just one sort of I was talking with a former consular officer about this, of all of the different policy updates and process changes coming out of the Trump administration, and it's like, each update is like a new little clog that can clog up, the
Hmm.
drain of the process. And this is just another one that not just applicants are dealing with, but practitioners are dealing with, and then on the back end, USCIS adjudicators are dealing with. When there's a policy change like this,
Hmm.
it does need to be disseminated throughout USCIS. There's confusion within, oftentimes within the agency as well, about how to apply these standards and the
Yeah.
changes. And all of those things can create further backlogs.
Yeah. I just want to talk about this thing. So, um, one thing that we need to understand with USCIS, the people who are adjudicating these cases, right? They have a lot on their plate. So we need to understand that. On the average, let's say a USCIS adjudicator is seeing 7 to 8 people a day, right? They need time to adjudicate these cases. And then all these policy changes are also coming into place. So that's a lot to take. And when I go in front of an adjudicator, I keep that in mind and I approach my cases to give them grace. I don't see it us versus them. I certainly think they have their job and I have my job, and I'm going to do my job really well. I expect them to do their job. But I think that approach for me helps me personally in terms of preparing for a case and then also advocating for the client, but doing it in a professional manner.
Yeah. I'm sure you would echo this, having interacted, with many USCIS adjudicators. I've talked to a lot of current and former ones. They all say that they love a very well prepared attorney and a very well organized file to look at. The easier you make their jobs, the better mood they have going into reviewing the application.
Absolutely.
Yeah,
Absolutely. I get told all the time, like, hey, this file's in order. That's great. I tell clients it's very important to have a close to perfect file, not have amendments. So if that means taking an extra day to file, it's okay because it'll make a big impression. If the adjudicator is to spend an extra hour on a file, it's probably going to go on the side. You want to move forward towards adjudication and favorably for your case. So yeah, I agree with that.
yeah, absolutely. Before we move on to the next story, I'll just note too, the one good thing about the N400, the naturalization application, is that USCIS does report on processing trends in a
Mm,
pretty timely way. Usually, there's about a 45 to 60-day lag from when USCIS releases the data. So right now we have June's data. We'll maybe get July's data in the next 2 or 3 weeks. We
mhm,
do track a pretty substantial sample of all pending N400s through
mhm.
Lawfully, so we can sort of see if there's going to be any change in processing times, approval rates, RFEs, etc. But it's having that USCIS data be released pretty frequently, I think, will help immigration practitioners, foreign nationals, and others understand what the potential impact of this policy shift could be, if any. Right, if any, we don't
Yeah,
know, like you said at the very beginning.
yeah,
All right, with that, let's go ahead to the next story, and I'll start by sharing the USCIS press release, but then we can jump into the actual policy alert. So this is the press release from USCIS. It came out 2 days ago. Now it feels like
okay.
it's been weeks, but this is a press release tied to a change in the USCIS policy manual. The press release here from USCIS, for those who are just listening, is flagging that USCIS is going to start considering anti-Americanism in in immigrant benefit requests. I'll
Mhm,
go ahead now, Shobhana, and share the next the actual policy alert so we can look at
sure.
that. And here's the actual policy alert tied to that press release. And then if you go into the USCIS policy manual, we actually did this with Doug yesterday
Mhm.
on the Immigration Insiders meeting. There are, throughout the different chapters and volumes of the policy manual, there are all of these new updates. But I'll let you go ahead and take the floor and sort of explain and take your time, because I know there's a lot. Explain what the changes are from this announcement 2 days ago.
Sure. I mean, I think this memo has a lot.
Yeah.
But the first thing I want to talk about is like this whole aspect of anti-Americanism, and how it's actually defined, right? Now statutorily defined. Obviously, it covers things like, anti-Semitism, terrorism, terrorist organizations, things that we all can agree with are not good. But uh, it seems to cover the anti-Americanism, seems to have a bigger umbrella on whether or not it goes to the whole issue of free speech, right? So, if I support Liverpool versus, I don't know, some football team, soccer team here, which okay, Chicago Fire, um, uh, is that anti-Americanism? I don't know. So it's a very broad spectrum, and I think many practitioners are are concerned to some extent that, look, what does that mean? What does anti-Americanism mean? There are a lot of things we can agree on. Like, there are a lot of things about, as I mentioned with the terrorism and all that stuff that we can agree on. But it is this overreaching anti-Americanism that is concerning and goes to free speech, and also to the issues of due process, I think, right? We're going to later talk about visa revocations and stuff, but it is those just those issues that concern me and practitioners, and the application of anti-Americanism, and it is combined in this memo with the whole issue of discretion, right? So one of the themes of a lot of these new policy changes is giving USCIS officers discretion. Discretion's always been there for a lot of these benefits, but now it's amplified, and it's going to be another area where an officer can look at a case, and whether it's they're reviewing social media or looking at something else, and say, look, we think it falls within this purview of anti-Americanism, which again I think is not as well defined. It's kind of a vague, to some extent vague, as good moral character is, and what fits into that anti-Americanism. And that's where the concern is, combined with the discretion aspect of it. And that brings me to the second issue of discretion, right? Like, they have amplified, USCIS has amplified on how much they're going to have in terms of discretion. Like, just to take, for example, USCIS is going to exercise discretion in adjudicating extension of stays, change of status, reinstatement of F and M non-immigrant visas. Again, that's been there, but this is an amplification of it. So what factors will be considered in terms of that discretion, and how can it be used, not as a weapon, but can it be used with misused or misapplied? Because obviously you have individuals and humans making these decisions. So there's a lot of subjectivity that goes into this decision making, and that's what is something that we have to see in terms of trends, right? The one of the other things that this memo touches upon is that the officer conducts a discretionary analysis on whether about an alien's application for admission or parole, made whether to see whether or not it was made in accordance with all applicable regulations and policies. Well, there are a lot of applications that are done by individuals where, just to take an example, for example, if someone's an overstay but they're married to a U.S. citizen, uh, typically that is forgiven and has been traditionally forgiven. Now, the fact that they overstayed, even though it's forgiven, um, how is that going to play in terms of the adjudication? Because now this person has initially violated the rules, right? Or let's say, take another example, those people who have conditional residence. Sometimes people file the wrong form, or it's late filed, and late filed applications for I-751s or lifting of conditions is accepted. But now that they've late filed it, so that is violation, or that late filing, how is that going to fall in the discretion of the adjudicator? So that's, again, I think, a seismic shift. Um, of course, we have to see the application, but um, I guess we have to figure out how the discretion is being used. Is it consistently used? Is it
Yeah.
jurisdictionally the same or not? Um, and so I don't want to jump to conclusions, but it is a seismic shift. But I think we'll just have to wait and see how the applications actually happen.
Yeah, I think with many of the changes in policy in the Trump administration, be it at state or USCIS, in this instance in particular, I always try to figure out, and this will be a waiting game. What's the scale of the potential implications of this? Right? Are there just a handful of applications that we'll start to see, different adjudication trends for, sort of odd RFEs or noids that we haven't seen before, or will there be thousands? Right? And if there are going to be hundreds or thousands, how quickly will that happen? We at Lawfully, we track all of the different case status updates from the My
Right.
USCIS page for all the different case types. And there's like, I mean, across all the different case types, there's hundreds, if not thousands, right, of different
Sure.
potential case statuses. And it's been tricky for us in the last 6, 7 months because there have been a lot of new ones that we hadn't been tracking before,
Hmm.
that are now being put into the my USCIS case update pages, so that we have to adjust to those in order to adjust our data. It's the same, and I'm sure you've seen this in your practice with the reasons stated on RFEs and on NOIDs for certain cases, and NOIRs as well, where there are new sort of reasons given that were unusual or not seen before.
Yeah.
I think that'll be the question here, and it's something that we might start to see trend shift in the next few weeks or the next few months, or we may not see it for a long time or ever, right?
Yeah.
But yeah, I was going to say that the big change here is, and you did a good job of really laying out all the specifics, is the level of discretion that adjudicators have, right? And that, again, I think inside of USCIS is what I'll be most curious to start to hear information about is how is this being interpreted by the rank and file.
Yeah, and I think one thing we have to watch for, and something that I watch for, is jurisdictional differences, right?
Mhm.
So, how is the Alabama field office going to see this memo versus
Yeah.
the Chicago field office versus the Dallas field office? Because we see the same cases sometimes being adjudicated with a different tone or tenor, and that for me is what is going to be very important. Obviously, I cover I do cases across, especially interviews, so I'm keen to see how that plays out, and hopefully there's some consistency in the application. But again, there's a human element with adjudicators being human. How is that going to play out? So we'll have to see.
Yeah, absolutely. Okay, with that, we can jump into the next story here. So this was a headline that was getting picked up, getting a lot of mainstream media attention, but it's sort of
Hmm.
an older story. And that's that back on August 18th, earlier this week, Fox News reported from an unnamed senior official at the State Department,
Hmm.
that they're reporting that they have revoked more than 6,000 student visas so far this year, for overstays and law violations. We don't know many of the specifics, other than that,
Hmm.
because again, this is just a story reported by Fox News from a unnamed source.
Hmm.
But we do know, if for those who have been paying attention, listening to this podcast, paying attention to the news over the last 6, 7 months, that revocations for students has been in the news, in the mainstream media news, and in the niche news that us immigration nerds pay attention to for a long time. And essentially what the State Department is saying here is that in totality, they've revoked about 6,000 visas. So I'll go to you for your reaction in general to this story and sort of what you think the implications of it are, Shobna.
Yeah. So, I mean, just to set the frame, obviously revocations have always happened, right?
Sure.
Every administration, revocations have happened. Definitely, I think revocations are more amplified. I, the number of revocations are going to be more. We're going to see that trend, but that in itself, I don't is the big story. It's like, how are we getting to the revocations is the story, right?
Mm,
So, what mechanisms are being utilized? Is it AI? Is it is what is if there's is there a due process of some kind being afforded? Um, because especially for F1 students who are spending a lot of money, a lot of time, effort, getting here, uh, and of course, there's just uncertainty, just in going abroad and studying. How do you get to the revocation aspect? And that is an enigma. I don't think any of us know that for sure. So I would, outside of the numbers, it would be interesting to find out or get some trends to figure out what are some of the ways and what are some of the cases that are getting revoked. Obviously, the most obvious ones where it's something really bad, terroristic threats and all that, bad stuff. Yeah, those are the obvious ones. But out of those 6,000, was it because it was just and I don't mean to minimize that, but was it because it was an arrest, right? And there
sure.
was no conviction? Traditionally, that would not have led to a revocation. But we also know in the last 6 months that that has led to CVIS terminations. There's been a lot of litigation on that, and there's been, obviously some rectification of that. So yeah, it is something that we have to watch, and then we have to watch. We talked about this whole memo of the anti-Americanism, and then of course social media watch. So how much of that is being a part of this revocation process is also going to be interesting to evaluate.
Yeah, absolutely. And I'll say this is going to be one where it's difficult to rely on the State Department releasing data. I live in the government immigration data. DOL is the most transparent.
Mhm.
USCIS is pretty good, pretty robust. But State Department data and ICE SEVIS data are both very, very difficult to trust, take a long time to come out, and include the least amount of detail in many cases, and are difficult to analyze. There are a lot of great reporters. Inside Higher Ed comes to mind. The folks over at NAFSA, the organization NAFSA, have
Yeah.
been doing a lot of work to, I think, understand what the individual revocations and what the trends are within this 6,000, and hopefully they're able to continue to do that and shed some light on this trend and this topic.
Yeah.
But like you said, and this could be a good segue into two of our next topics, which are a little bit older, but I think they're worth revisiting, and I want to hear what your take on them
Hmm.
is. Which are, first, we can start with the new restrictions around the visa interview waiver program, which
Sure.
at this point is a month-old story, but
Yeah.
it's becoming more and more relevant right now. And I'll share my screen here with the State Department update because the change is going into effect in just a couple of weeks here on
Hmm.
September 2nd. So I'll let you go ahead and explain sort of what the change to the visa interview waiver program is and what's going to happen on September 2nd.
Sure. So before this change, there were a lot of visa categories which were eligible for visa waiver. You did not have to go in person for an interview. You could drop off documents at a Dropbox if you're eligible. And there were obviously certain disqualifiers like arrest, criminal records. But people didn't have to go in for stamping. And from a logistical standpoint, from a non-immigrant perspective, in making someone's life easier and providing more certainty, that was really a great feature to have, right? And being able to have some certainty that, yeah, you're going to be able to hopefully get approved and come back and either continue your studies or continue your employment. This change of two interviews is not only just with the consular processing, but we're also seeing it on the adjudication side of USCIS, where almost every case is going to get an interview. So it's actually not surprising that it is also come to the consular side. So now, effective in September, consular interviews, barring some exceptions, like for diplomats, certain B1, B2s, where you have to have applied from the country, the renewal has to be within 12 months, and you shouldn't be disqualified for something else. Everybody else is going to need an interview, right? Um, and that's going to impact the non-immigrant community, H-1Bs, Ls, significantly, because a lot of those individuals in that community were using the visa waiver program to provide some certainty. So um, the outside of the more uncertainty for this community, question is going to be, are interview dates available? Okay, especially in high volume posts like India, the Philippines, and there's some, of course, there are multitude, but I do a lot of work with India, so I'm familiar. Sometimes it's 100 days out, 300 days out. So when are you going to get that interview? And then if you get the interview, obviously, the how quickly is it going to get adjudicated? Are you going to go into 221G? So these are all these factors that will come into play. One of the things that the way I'm approaching this it is what it is, right? It's the same thing from my perspective, stateside for adjudications. We went for 4 years without any interviews to every interview possible. I just did an interview on Saturday in Chicago. That was my first Saturday one, so it was interesting, but that's the norm now. So the way I intend to approach these is that we know the interviews are coming. So if you have an interview coming, you need to be prepared. That means your ducks in a row with all your documentation. If you have an arrest or some criminal issue, I would suggest hire counsel, discuss it, how to present it. This is not the time to DIY it, especially when it is a more complex issue. It's especially when I talk to people, I say, look, it's an investment in yourself. So you need to consider getting and seeking guidance because it could be the make or break, especially for people who have, let's say, been in the country for 5 years on a H-1B and they're going back for stamping. And all of a sudden now they can't get an interview or the case goes into 221G. They have a house, they have a family. Everything is disrupted. So the preparation is going to be a key element on how these interviews go. And then, of course, trying to get the interviews. I think some people will be looking at third country for interviews, and that's going to be, I think, acceptable, especially if the wait times are exceedingly high. Traditionally, looking at third countries always hasn't been looked at favorably because it's been questioned as shopping forums, but I don't think this is one of those scenarios. If you can't get an interview date for 300 days, I think it's legitimate to be able to find another post to help you. So um, I understand some of the concerns that people have with it. I share some of them, but I think you have to approach this change as just solution oriented, and that's the way I'm approaching it.
Yeah, it's a great point. I'm not sure if you saw this, but my friend Cecilia Esterline over at the Niskanen Center just released some new research on appointment wait times
Mm,
for all the different consulates. And she highlights a few of them here in this screenshot in her LinkedIn post. And I'll link the full article so folks can go and read it. But before this change, this restriction for visa interview waivers, has gone into effect, like we said, it won't be for a couple of weeks. Estimated wait times for interviews since early January of 2025, through now through August have increased quite a bit. Hyderabad sticks out, right? For
yeah.
petition-based workers, it was 15 days back in January. Now it's up to 3 months. I mean, some that were already pretty bad. Monterrey, Mexico, 232 days, about 7.5 months. Now at 12 months. Obviously, and I'm sure we could list many factors. I think the pause on FM and J interviews that lasted about 20 days between May and
Mm-hmm,
June of this year, during the peak season for F interviews in particular, where
mm-hmm,
hundreds of thousands of students are trying to get their visa interviews, either to renew or to get their first visa to enroll in U.S. university in the fall, caused a lot of this backlog. But I think there are other factors as well, and yeah, the cancellation of the visa interview waiver program could just contribute to this. But I agree with your point that this is like the weather, right? It is what it's going to be what it's going to be, and you have to find the solutions that work best for your individual
yeah.
case.
I mean, I would tell people plan early, prepare well, and be ready to execute well at the interview. You need to know why you're applying, what kind of visa you're applying. These are going to be those are non-negotiables, and the interview is where the decision is made. So the preparation and the ability to communicate and be your own advocate, as I tell clients all the time, is essential for consular processing. The attorney's not standing next to you, so you have 3 to sometimes 90 seconds to 4 minutes to make that case. So you have to be succinct and effective in communicating.
And then related to that, again,
Mhm.
this story is a week or two old now at this point, but I think it's still relevant to this topic, on sort of the trends at the State Department of the consulates abroad. Is the new visa bond pilot program that was announced by Secretary of State Rubio a couple of weeks ago. Right now, it's only impacting two countries for B1, B2 visas. I actually analyzed the issuance data for both of these countries over the last 12 months. It's
Mhm.
really only impacting like a few hundred, maybe a few thousand people in total from these two countries in particular. But the word pilot, I think, is really the key here, right?
Yes.
And the amount, the bond amount, 5,000, 10,000, or 15,000, is also significant. So I'll go to you. What's sort of your take on the rollout of this rule and where you think it
Yeah.
might go from here?
So, they've talked about this bond stuff. It's not the first time the discussion has come up. It came up during the previous term of this administration. But so a couple things that stick out to me is it's a pilot program that could extend beyond B2 visas to F1s. And that to me is where I think it could become uh, very disadvantageous to certain parts of the world versus other parts, right? Who don't have the ability to provide a bond of 5, 10, 15,000. So that's something that we have to look for in terms of how this pilot is going to get rolled out and how if it's going to extend to beyond just bees. The second thing is the actual implementation on this program is what I am uh, curious how it's going to work. I know it's laid out that a recommendation of bond is going to be made. You have to pay the bond through the government of the Treasury Department, and then you will get a limited visa, and then you have to return um, within that time period. Otherwise, you forfeit it. But I can see a lot of issues that could come up in terms of um, return. Sometimes the documentation on return, even if there's timely return, is not accurate. Um, I have a case where we know when the client came in and didn't leave, but if you go online to the I-94, it shows he departed the country, but he
Uh,
didn't. He's still here. So, and that's not atypical. I mean, I hate to say that. So, I am concerned about the bond forfeiture for people who do follow the rules and do leave on time. Um, the In terms of the technical glitch, and then of course the interlying issue is that let's say you have a family of 3 who wants to apply for a B2 visa, and a bond of let's say 5,000 is recommended for each of them. Well, that's $15,000. And, so it becomes a socioeconomic issue. And how dissuasive is it for people who want to come and visit the U.S., have heard great things about the U.S. and want to go and see Disneyland, right? So if you're coming to see Disneyland and you're having to pay $15,000, can you now afford to go to Disneyland? I don't know. So that the cost aspect is also there. I know it started out with Malawi and Zambia, so the another aspect is to see where is it going to roll out next. Uh, and I'm looking forward. I mean, not looking forward. I'm looking to see where that happens. Um, the final aspect of all of this is that traditionally, obviously, you cannot come in on a visitor visa with the intent to do something else. Okay. But sometimes, and let's use COVID as an example, people came in on a visitor visa to, let's say, they see their girlfriend or their boyfriend with no intention of adjusting or changing status. But COVID happened and they couldn't go back. And they were in committed relationships. And they said, you know what? We are going to be together. We want to get married. So there was a change of circumstance outside of this. There was no preconceived intent. And many of those individuals did get married, did adjust. But with this bond program or pilot program, if you do adjust, even if it's legitimate, um, you forfeit that money, which is a significant amount. And uh, so I think the question is whether this policy shift takes into account some of the historically accepted norms and changes and practices and life. Life happens. So I'm just interested to see that. I do think that the imposition of the bond, the amount is high.
yeah.
The final point I want to make on this is it leaves, again, this is an overarching issue of discretion, right? It leaves the decision to the adjudicator. So the consular officer. And I'm sure that at every consulate, there's going to be some kind of protocol on how you make that the adjudication and recommendation to the NIV chief, and if there's going to be some kind of approval process. I'm sure there's going to be something like that. But um, how that discretion aspect is there and how that decision making is made again seems like very like an enigma to me. So yeah, those are some of the things that I got out of this new program.
Yeah, no, that's a great overview. And I always hammer on this point in the podcast anytime we talk about State Department updates, but the consular officers have a lot less oversight and a lot more discretion, I think, than any other of the immigration agencies that are based inside the U.S. Or that are based inside the United States or processed inside the U.S. CBP,
Hmm.
USCIS, ICE, etc. It's far more difficult to litigate against or appeal decisions made by consular officers, and there's very little record of sort of like, for example, the State Department doesn't report on denials with the same
Hmm.
timeliness that USCIS does. We can't see those trends in advance. We have to wait, 16 to 18 months to see them. So it's a little bit more difficult.
Yeah, we can't get FOIA. We can't get the
Yeah.
records from the consulates. Usually, it's very, very difficult to get the FOIAs. So, unless your client, and I would advise someone, whoever is going for consular processing, to as soon as the interview is over to keep a record of all the questions asked, everything from the point you moved in, get what went inside to the security checkpoint to the time the interview happened, because you need to have a contemporaneous record of what you experienced for yourself, and if you have counsel for them to assist you if you need assistance. But uh, that is something that we just have to sort of see. Another thing I think is going to be interesting is to see how many people are going to pay this bond.
Yeah.
Uh, so I would be interested in knowing, one, how many recommendations were made, and then how many people could afford it. Because if people can't afford it, I don't know where this pilot program goes.
Right. That's a really good point and something that we'll keep an eye out for. Okay, our last sort of big story here is again one that's a couple weeks old, but we haven't covered it on the podcast yet. And part of that's because I saw it, but I didn't know a lot about it. But it's the perfect story for you to cover because it's right up your alley.
Yeah.
So this is a policy alert from USCIS. Changes to the policy manual, specifically on family-based immigration petitions. So can you break down what the changes were and sort of what the
Yeah, I mean,
implications are?
I'm gonna go to what I think is the heart of this policy change, at least for me, because I do a lot of family based, and it is to give uh, USCIS the ability to issue an NTA um, in a family-based petitions. Let's say you're married to a USC spouse, you've overstayed, which is again traditionally pardoned inherently. Now, USCIS has the ability to adjudicate, again, goes to the overriding issue of discretion, to issue an NTA. Traditionally, we do not see USCIS being an enforcement mechanism, right? It has been a mechanism to provide immigration benefits. So there is a seismic shift, and then issuance of the NTA, where someone now has a pending application. You're married to a U.S. citizen, but you could be found to be removable. That is seismic. And I think in the immigration community, the questions that are being rightly raised is, well, when is that going to happen? How is that determination made? Is it going to be different from one field office to another? Um, and I know, being in the immigration community, um, when an interview is coming up and someone has a client who has an overstay issue, um, the concern is there going to be detention, or will an NTA be issued? So, uh, there's been a lot of policy changes, but for me, significantly, this is the biggest change. And you know, it may change how family-based immigration practitioners, what type of cases they take, how they take it. We'll just have to see the implementation on it. Um, I want to, though, be hopeful on this and you know eh, again, it goes to the whole issue of discretion. And I am very, maybe I'm too hopeful, but I'm hoping that um, this policy shift is judiciously implemented versus arbitrarily implemented, because otherwise I think it will create a lot of chaos and uncertainty, which already extends to some extent. Um, Another thing that I wanted to look at here, let's see. Oh, and this is already happening, and I touched upon it, is that um, it's going to require interviews for family-based cases, right? So obviously, for spouse-based cases, interviews have started. Traditionally, for parent-based cases where a U.S. citizen was petitioning for their parent, we didn't always say interviews. We are seeing interviews. I just had a case where interview scheduled in September. Um, and someone engages me for that, that's something obviously I lay out. But those interviews, I mean, I've gone to those interviews, and in one of those interviews, I was asked, "Why are you guys even here?" And this is pre this era, but I looked at the officer and said, "I don't know why we're here because you have already approved the I-130, and it's a pretty clean cut case." Case was adjudicated fairly fast,
Yeah.
um, but we are going to have to go through the process of interviews. And, you know, I look at things that, I don't look at everything as doom and gloom. That's just not my approach to things. Definitely, there have been some dramatic changes, a lot of changes that have brought angst to a lot of people. But coming to this issue of interviews, again, they are there. You do have to deal with them. So prepare accordingly. We are seeing adjudication of cases, approval of green cards, people getting naturalized. Again, a lot of dramatic stuff happening, but the process for many people is still working. So we just have to I take it day by day and client by client. That's how I'm just approaching it.
Yeah, you've made this point, I think, several times throughout the podcast. We've looked at, which I appreciate, because we've looked at three pretty substantial policy shifts, today, that have been released in just the last 3 weeks. And, and the point you've made is that, like, we don't know if these are going to actually result in seismic implications, right? The policy shift might be seismic, but the implications may not be. I think in the immigration practitioner community, and for good reason, a lot of folks are quick to immediately worry that a shift in policy is going to result in huge changes to adjudication practices, massive RFE spikes, denials, NTAs, if as we have actually been seeing
Hmm.
increase over the last couple of months. But it's not always the case, right? And so even if it is, like I said before, it's a matter of scale and how many folks it impacts. And look, the more information we get, and I'm sure this is something that you keep a very close eye on. The more information we get, anecdotally, from other immigration practitioners, from foreign nationals themselves, from the USCIS data, from the data that we track at Lawfully, I think the better equipped, smart, agile practitioners like you are to be able to pivot and help their clients, succeed in their individual cases. And that's an important point that anyone listening should sort of keep in mind.
Yeah, I agree.
Okay, one quick story from the courts that we'll skim over, and then we'll jump into the under the radar trend that you're tracking. So this is we share an article, at least one article from him every week. Our friend Andrew Kraybaum over at Bloomberg Law. The ongoing saga around both the Trump administration's efforts to terminate TPS and you know get the legality, the approval to deport anyone here who's previously been on TPS, continues to ping pong back and forth in the courts. And the Ninth Circuit this week ruled in favor of the Trump administration on some of their efforts to
Yeah.
deport about 60,000 migrants from Honduras, Nicaragua, and Nepal who previously had temporary protected status here. So again, something we'll continue to keep a close eye on. I'll link the article that Andrew wrote here, so you can go and follow it if you're interested. But with that, Shobhana, I want to give you the floor to sort of end the podcast here with a story or a trend, something that you've been paying close attention to that you think might turn into something bigger, might impact more immigration practitioners or their clients or foreign nationals, but maybe is more under the radar for the community right now.
Sure. So, I don't want to, there's no specific case, but I want to leave people with hope. Um, there's been lots of memos, a lot of anxiety for the immigration community and immigrants and non-immigrants, and I get it. I'm living it day by day, and I feel it too. But I've had a lot of time to reflect on it. And something that I mentioned earlier in the podcast is that I am going to interviews. I am seeing green cards approved. I am going to interviews. I am seeing clients naturalized. I'll give you an example. I flew to Alabama on Sunday for I-751 and N-400 interview on Monday, and it's a very small office, but they're very judicious, and I-751s require the spouse to be there. But when we reached, they said, no, the spouse can stay in the car. I was like, what? Because they'd already approved that petition. So now they just wanted to adjudicate the N-400 and see if my client passed the test. My client's 8 months pregnant, but we were in the officer's room for 15 minutes. Everything went well. It was adjudicated. We had submitted over 300 pages of bona fides. He didn't even want more. So I was like, great. Um, and as the case was approved, he turned around and he said to us, are you ready to take the oath? We have a ceremony in 30 minutes. Which we don't have save the oath ceremonies here in Chicago. So my client and I looked at each other. We're like, yeah, heck yeah. And I had a flight to catch, but I said, no, I'm gonna see this through. I want to be there for the oath. So we waited for 30 minutes. Her parents were visiting and her husband was there, and we could all see her becoming a US citizen. Um, and it was such a good feeling. I mean, I'm myself a naturalized citizen, and I love to go to actually the oath ceremonies. I don't get a chance to as much because you see the fruition of a goal for many immigrants and the honor that they feel in becoming U.S. Citizens. So I say this story because with all the noise, all the um, not necessarily chaos, but anxiety people are feeling, the system is working. Things are moving. It's not perfect. And there, again, I don't want to detract from some of the things that people legitimately have a concern for. But I also want to leave people with hope. The other thing that I want to talk about is I feel so many calls a day, and I tell people that really you need to get sound legal advice. I said this earlier in the podcast. This is not the time to DIY it, especially someone who might be uh, potentially detainable or removable. They need to get legal advice so that they can have a plan of action in place, whatever that may be. Um, it is much harder to represent, and this my colleagues who do removal defense will tell you more than I can. It's harder to represent people who are already detained, and uh, you know it, it's best not to bury your head in the sand and say it'll be okay. No, you need to have a plan of action. So that would be the second thing I would say. And then my final ode is to all the immigrants, non-immigrants, and all Americans, right? Like, we all may have differing opinions. I do believe this is a country of immigrants. I'm myself an immigrant, and I think immigrants are hardworking. But whatever your perspective on immigration is, I would encourage people to have a civil discourse as best as possible. And again, like I said, um, not to jump to conclusions on every single memo until we start seeing some of the things. Again, I'm not trying to take away from some of the things we've already seen has caused me anxiety, but I want to be pragmatic in my approach to things. And I would ask others to consider that.
Well, it was well said. I think that's a great place to end it. One final housekeeping note before we do, though. Tell folks where they can follow you, where they can reach out to you, and if there's anything else you want to plug that you're working on, that you're excited about, that you want to share with listeners, please go ahead.
Sure. So, my website is KasturiLaw.com. I'm active on LinkedIn, so you can find me under KasturiLaw.com or Kasturi Law or Shobhana Kasturi. I will be starting a new YouTube channel, and I'll be more active on Instagram. But I love LinkedIn because I get to write stuff there. So you can always find me there. And if I can be of assistance, I'm happy to help out.
Recommend following Shubna on LinkedIn. That's actually where I first got in touch with her and invited her on this podcast. A lot of people are posting on LinkedIn about a lot of these policy updates, but she has a very unique point of view that I always think is grounded and is interesting and will help folks sort of navigate through some of the noise that is perpetuating the space right now. So we'll leave it there. Shubna, thank you so much for joining me today. It was awesome to have you on to have all your insights on the news of this week and this month and the entire landscape right now. We'll have to have you back on again soon, and I hope you have a great rest of your summer in Naperville in the meantime.
Thank you, Finn. It's been an honor, and I'm wishing you and the rest of the audience a good rest of the year.